Yes, good evening to everybody. Welcome to the today class of the law of incidents that I was giving the last class. I was dealt the insurance contract and indemnity contract. Half of the portion that I did it, the rest of the portion that I would like to make it out. Before I could go further, let me confirm myself that whether you are with me and I am with you, so that we are traveling the same boat to reach to the destination or not. Yes, read what I posted on the screen.
Good
Good
evening.
evening.
Okay.
Differences between life insurance policy and contract of indemnity. Life insurance policy, contract of indemnity.
Yes. Yes, these
Thank
are
you,
the
Professor
things.
Dr.
Yes.
M.S. Hussain.
Yes, these are the things that what I want to make it out. And regarding the insurance contracts or indemnity contracts are concerned, yes, there I have made indemnity contracts. Yes, and I covered. I will show you that how much I covered it. Because let me close this one, then you make the find out. Then the asterisk I put it over there up to that extent that I covered in the last class, and asterisk is yes, it went over there. Yeah, it came to the asterisk. Yes, up to this extent I covered in my last class. Yeah, that is a right to recover the sum paid under the compromise. That is section 125, subsection 3. An indemnity holder means a person who is indemnified also has the right to recover from the indemnifier all sums. All sum indemnifier means here insurance company, all sums which he may have paid under the terms of any compromise. If any compromise is made between the victim as well as the indemnity insurer, indemnity holder, at that instance, whatever the amount paid by the indemnity holder to the victim, that amount will be reimbursed from the indemnifier, that is the insurance company. If the compromise is not contrary to the order of the promisor, yes, the promisor here is the insurance company. The insurance company not contradicted with the promise and was one which it would have been prudent for the promisee to make the absence of any contractual indemnity. Here the promisee in the sense indemnity holder. So indemnity holder has made such a thing, and when he compromised it, the amount which will pay to the victim, that is a person who got injured, then it can be reimbursed from the insurer, provided it is not against the promise which is made with the promisor, that is the insurer. So that is the whole idea behind it. I believe it is clear.
Yes, sir.
Very good. The commencement of the liability of the promisor or indemnifier. The promisor means indemnifier only, virgule. That's why I put the virgule. That is oblique, or we can say stroke, or we can say, what is another name for the virgule? What is the synonym for the virgule? Number 1, slash. Number 2, stroke. Number 3, oblique. Okay, Indian Contract Act 1872 does not provide the time for the commencement of the indemnifier's liability under the contract of indemnity. But different high courts in India have led the following rules in the regard. Because whenever the victim is, whenever the victim would be there under the insurance contract, then they have to bring to the notice immediately to the insurer. Number 1, if it is an accident, then nearest police station, then he has to make the complaint. So these are the things one should have to do it and see that whether the vehicle is insured or not. If it is insured, with which company that is insured. So indemnifier is not liable. Indemnifier is not liable until the indemnifier has suffered the loss. So insurance company will not be liable unless until the indemnified has suffered the loss. Means the policy holder suffered the loss. Is it clear? Is it clear?
Yes, sir. Yes.
So indemnified can compel. Indemnified can compel means policyholder can compel the indemnifier means insurer or the stakeholders to make good his loss, although he has not discharged his liability. Even though there is some fault would be there from the indemnified, but still it will be covered by the insurer. So in the leading case of Gajanan Mureshwar versus Mureshwar Madan, I repeat, Gajanan Mureshwar versus Mureshwar Madan, an observation was made by the judge that if the indemnified means policyholder has incurred a liability, has suffered a loss, and the liability is absolute liability would be there, he is entitled to call upon the indemnifier, and he can have the right to call the indemnifier means Who is the indemnifier? Insurer, stakeholders. Is it clear? Say yes. Is it clear? Bhaktullara, is it clear? Any problem? Is it clear or any problem? Participant, yes, read. One can unmute and read this one so that I could know whether you are with me or not. Unmute and read this one which I highlighted. Participants, unmute and read.
If the indemnified has incurred a liability and the liability is absolute, he is entitled to call upon the indemnifier to save him from the liability and pay it off.
See, when one is reading, the another also reading, that means you participant doesn't have that somebody is reading. I could hear the voice of the person who is loud. That is the Venkateshwar voice very loud, and the lady voice is very much less. She is also reading.
Real, sir. Real, sir.
When I say
Both are
when I say read,
very
it means
to
everybody is copying.
read.
The read in the chorus. Okay, no matter, no matter. I will give the explanation. If the indemnified has incurred the liability, means the policy holder incurred the liability or injury is caused to him, the liability is absolute. When the liability is absolute over there, he is entitled to call upon and he will call the indemnifier, that means a stakeholder, and to save him from the liability to pay it off. So he will ask the insurer to come to his rescue. His rescue means indemnified rescue. Thus, a contract of indemnity is a special contract in which one party to contract, within parentheses, that is id este, the indemnifier, promises to save the other is who is indemnified, means policy holder, from the loss caused to him, means indemnified holder, by the conduct of the promisor himself. Even the indemnified promisor himself also, there is negligent would be there, but still he could get it. By the conduct of any other person, or any other person made such a harm, or he is violated over there, but still the indemnified will be rescued by the insurer. That is the indemnifier. So that is the whole gist of it. Section 124 and 125 of the Indian Contract Act 1872 are applicable to these types of contract. Now let's see the historical development of the principle of indemnity. Indemnity was restricted only to the loss occurred by the Home and Agency only. So indemnity generally the loss occurred to the Home and Agency only. In case of the natural disaster, provided it will be there in the policy, then it will be covered. Otherwise, it will not be covered. Is it clear? Again, the same thing is mentioned in the Gajanand Moreshwar versus Moreshwar Madan. It is stated that this is definition covers indemnity for loss caused by human agency only. That means it does not deal with those losses of the cases where the indemnity arises from the loss caused by the events or accident which don't or may not depend upon the conduct of the indemnifier or any other person, or by reason of the liability incurred by the something done by the indemnified at the request of indemnifier. So, if any human agency would be there and there the cause is occurred over there, at that instance, insurer would have to come to the rescue of the insured. Is it clear? It does not deal with those classes or cases where indemnity arises from the loss caused by event or accident. If the events or accident which don't or may not depend upon the conduct of the indemnifier, means who is the indemnifier here? Who is the indemnifier? Insurance company, indemnified, policy holder, or any other person by reason of liability incurred by something done by the indemnified beholder at the request of the indemnifier. So now the question comes over there. Whatever the terms and conditions is stated in the contract of indemnity, that will be holds good, but not extra amount. Whatever the amount agreed over there, that amount only will be paid by the indemnifier to the policy holder or any other person who is got injured because of the fault or without the fault of the policy holder. If the policyholder fault would be there at that instance, the insurer will step into the shoe of the policyholder and try to reimburse the amount from the policyholder. Or if any other person is 100% negligent and is a part of it, then it will be claimed from him, but not the injured. Suppose the injured is a 100% fault, at that instance he is not going to get anything because his fault is 100%. And I told you in my classes also earlier that suppose if you did not wear the helmet, how much the deduction would be there?
1035 rupees, sir.
20%. I am not asking for the fine. Fine is 235 rupees now. If you don't wear the helmet, the police will make challan, 235 rupees. I am asking, suppose a person did not wear the helmet and he got injured and the vehicle is insured over there, how much the deduction would be there for his negligence? For his negligence, he contributed for the accident, the negligence is 20%. That means, suppose if he is going to get the 100 rupees, then the 20% means how much it will be deducted? 20%. How much would be deducted out of 100? 20%.
20 rupees, sir.
20 rupees deducted and 80 rupees will be given to him. Simple mathematics I am asking you. Okay, read this contractual, anyone, not chorus. Anyone could have to read it. It is the contractual class. अरे बेटा मैं क्लास में हूँ रे बेटा, बाद में बात करते हैं. Yes, the contractual agreement document must be stated clearly in terms of the conditions and indemnity. In the State Bank of India and another versus Mula Sahakar Karkhana Limited. I repeat, the State Bank of India and another versus Mula Sahakar Karkhana Limited. It is stated that a document, as it is well known, must be construed on the basis of the terms and conditions contained in therein. Where the terms and conditions contained therein means where it is? Where it is? Sir, on the blackboard.
On the policy documents.
On the whiteboard.
Sir.
Yes?
On the policy document.
Policy document. Certification, bond. That is the instrument. It is also tried that while construing the document, the court shall not apply any words which the author therefore did not use it. The document in the question is a commercial document. When the commercial document is made, it should be construed strictly, not of his own choice, what he says and what he thought. It does not on its face certain an ambiguity. The High Court itself said that ex facie, the document appears to be the contract of indemnity. Surrounding circumstances are relevant for construction of the document only if any ambiguity exists therein and not otherwise. If any ambiguity arises over there in the contract terms or at the time circumstantial evidence would be taken corroborative, then the meaning will be given as it is. Suppose if I say the plant causes pollution in the air, then what do you mean by plant here?
Company, sir, industry.
Company, manufacturing company, establishment. That is not biological plant.
Yes. Chemical plant or any other plant.
The contextual meaning should be taken into consideration at the time. The said document, as per the Supreme Court, constitutes a document of indemnity and not document of guarantee, and it is clear from the face that by reason thereof the appellant was so to indemnify the cooperative society against all losses, claims, damages, actions, and costs which may be suffered by it. In any cost, whatever the terms and conditions would be therein in the policy bond or the certification would be there, that would only be indemnified. If any excess damages is caused over there, then the insurer will pay what is the agreed amount in the document, then the rest of the amount will be borne by extra amount, borne by
Property owner.
Borne by policy holder from his own pocket. Indemnified from his own pocket. Policy holder from his own pocket. The extra amount should be borne by him. So now the document does not contain the usual words found in the bank guarantee furnished to the bank, as for example, unequivocal condition the cooperative society would be entitled to claim the damage without any delay or demur. Or the guarantee was unconditional and absolute, as held by the High Court. It is beyond any civil, beyond any cavil or annual, that a bank guarantee must be construed on its own terms. It is considered to be the separate transaction. So whenever the commercial transactions are there, if the words are very much ambiguity would be there, then the circumstantial evidence will be taken into consideration to give the right meaning at the context. That is what the case law says. Okay, let us see. Anyone can unmute and read what is the contract of insurance? Anyone can unmute and read. Only one, not chorus. Better I will pinpoint them so that they can make it out. Sai Harshini, unmute and read. She is not there.
Contract of insurance. Insurance will be defined
I said Sai
as a
Harshini.
contract.
I said Sai Harshini.
Sir,
Only Sai Harshini should have to read it. Read.
insurance may be defined as the contract between two parties whereby one party called insured undertakes in
Insurer.
exchange for the fixed sum called premium
Say loudly. What? No murmuring sound. Sonorous voice. Read.
to pay the other party called insured a fixed amount of money on the happening of the certain event. It means protecting against loss. It is the process of safeguarding the interest of people for loss and uncertainty. It is based on
You
the
have to keep
contract.
your
It is
you have
a
to
valid
keep your
agreement that
smartphone very near.
incorporates
Otherwise, the
certain
voice is
terms.
very much low. Your voice is very much low. You have to increase the voice. Anyway, okay, stop. Stop. Insurance may be defined as a contract between the two parties. Either the contract also will be defined as the contract between the two parties, whereby the one party is called the insurer, here is the insurance company, and the contract of insurance, and the exchange for the fixed sum called the premium, which is the consideration paid by the policy holder to pay the other party called the insured a fixed amount of the money on the happening of certain event. Suppose the event happened, may not happen, first and foremost that he has to pay the premium. It means protection against loss. It is the process of safeguarding the interest of the people from the loss and uncertainty. So if the 100 members are there, then they collected the premium at least, say about the 100, then it becomes a 100 into 100, it becomes 10,000. Is it not? At that instance, if anybody untoward incident happened to one of the policy holder, then the amount would be claimed over there, fixed, say about the 3,000 or 4,000. If the 4,000 will be paid from the pooled amount of 10,000, still 6,000 will be there in the stock of the insurance company. The 6,000, what they do is they keep in the investment and see that it will be increased. It is based on the contract. It is a valid agreement that incorporates certain terms and conditions. So insurance contracts are nothing but indemnity contracts. It may be described as a social device to reduce or eliminate the risk of loss to life and property. It is such a device, such a method where the risk will be distributed among the other policyholders. So it is a device to reduce or eliminate the risk of loss for the life and property only on the one person. So the other person whose amount are pooled up in the form of the premium, that amount could be used, the pooled amount will be used over there to give the rescue to the person who got injured because of the untoward incident happened to the policyholder. So insurance business and the need for the insurance cover are growing with the growing complexity of life, because now life is a very miserable. When you go on the road, we don't know how safe that will come back. Are you following me?
Yes, sir.
See, if you are going on your own side, but a person who is coming from the back, if he hit you, no fault of you, you will be die or you will be injured. At that instance, we cannot determine how the complexity of life would be there, and trade and commerce, because many other things, and consequently there are a lot of chances for the injury and a lot of chances for the casualty also. There is now bewildering variety of the insurance covers. Bewildering means astonishing. and we can beyond the reach of, because now the new insurance policy is Omicron policy. Are you following me? Say yes.
Yes, sir. Yes, sir.
Yes, sir.
Yes. But marine and fire and life are the most common variety of insurance. Whatever be the kind of the insurance or the risk insured against, there are certain principle of insurance law so fundamental that they impinge upon every variety. Every contract of insurance except the life insurance is a contract of indemnity. I already told you several times also this. Why the life insurance contract is not called the contract of indemnity? I would like to get the answer from anyone. Yes. Yes. I would like to get the answer from anyone, not in chorus. Only one can say, or pinpointly shall I ask a particular person or not. Yes, Tandori, Arshini, Sanjay. Sanjay Rani, you tell me. Sanjay Rani, you tell me why the life insurance contract is not the contract of indemnity. If you don't know, you say pass
Sir.
on.
Sir,
Sir, pass on, sir.
Yes, another person.
because of it is only risk based, sir.
Of course, you are not exactly, you are beating around the bush. I told several times, we cannot ascertain the cost of the life. I repeat, we cannot ascertain the cost of the life. Hence, life insurance is not the contract of indemnity. Okay, this person's life is this much. Okay, let him pay the only 5,000, 10,000, 10 lakhs, 1 million, 2 million. How do you make it out? What is the parameter would be there for the life? Okay, generally we will say, suppose he is a businessman, if he is a professional, he is a so and so, only we will equivalent amount of compensation by making the different slots, we can make it out. But doesn't mean that we can indemnify it. Life you cannot indemnify it, because life cost is we cannot count it, ascertain in the terms of the money. That's the reason life insurance contract are not the contract of indemnity. Only that contract of indemnity is general
Insurance.
insurance.
General insurance.
General
Several times
insurance.
I told you, but still people are not in enough to give the right answer for my question. Every contract of insurance is a contract of absolute good faith and requires some insurable interest to support it, without which it will be a mere wager. So now we will see the what is the wager, what is the contingent. But here we will see that what are the essential conditions for the indemnity of the contract. In order to offer an insurance contract to be legally binding, certain essential requisite must be stipulated in the contract. These elements are classified into two broad categories. Number one, the elements of the general contract. There is offer and acceptance, then consideration, legal capacity, legal purpose, and free consent. The elements of the special contract in relation to the insurance company is concerned, then it is the indemnity, insurable interest, utmost good faith, over fide, so subrogation, assignment and nomination, warranties, proximate cause, return of premium. These are all the things that we studied in the general principle of insurance. The general elements of the contract be further elaborated as follows. The insured make an offer by submitting an application for the insurance company. This is the ordinary procedure. The insured accepts the confirms the application, issues the policy. Then insured makes an offer by submitting the application to the insurance company. That means the insurer will give the offer to the insurer. The insurer will give the offer to the insured, and the insured will submit the application to the insurer. The insurer accepts the confirmation and application, issue the policy. In Hindustan Cooperative Insurance Company versus Shyam Sundar, I repeat, in Hindustan Cooperative Insurance Society versus Shyam Sundar, here cursor I am showing, after an oral understanding to the insurance and the completion of the medical examination, the company informed the proposer means who, that if he submitted the proposal from a forum and deposited the half yearly premium, his proposal would be accepted. There is a condition put by the insurer to the insured. He means insured, accordingly submitted a check but had not replied to him their acceptance of the proposal, and the proposer died. See, when that till the acceptance is not made by the made by the insurer, and meanwhile, who died? Proposal died, means indemnified died. Then what will be the validity of the insurance contract? The question was whether by cashing the check, the company had accepted the proposal without there being a formal acceptance. So unless until the check will be encashed over there, then you will not able to the acceptance. Am I right?
Right, sir. Correct, sir.
Suppose if the DD, as soon as he receives, is not that he encashed it. Is it or not? Because DD amount, there
Yes,
is no
sir.
question of
DD
balance
amount
is
is
there or not.
DD is very quickly cashed, sir.
It is equal to the cash down.
Yes, sir.
So in the case before, it is clear from the facts that the deceased indicated clearly that if the appellant accepted his proposal, the check should be appropriate toward the first premium, and that such appropriation would be concluded the bargain. The check was received on that implied understanding. So now, when on the other hand, the insurer had received the proposal from the along with the first premium, it was still awaiting acceptance. When the proposal dies, no liability to pay arose. It was immaterial that the groundwork for the acceptance was like under preparation, and the agent had assumed that the proposal should be accepted. If merely giving the check, it doesn't mean that he paid the premium, unless until it is encashed and it is accepted by the insurer. Up to that extent, we cannot say that it is a legal binding insurance contract. In case if it is given the DD in the form of a premium, it is nothing but cash down, and if it is accepted by the insurer, then it is a valid contract. So that is very much important. So as usual, we know the consideration is there. Here the consideration is the premium. Is it or not?
Yes, sir.
What is the legal capacity? Sane mind, age, no convulsions. At the time of making transaction, he should not be in the convulsions. He should be know the real condition, what he is going to do. A minor, what about the minor? Whose behalf of the goods are insured? A minor allowed the minor to recover the insurance company. On behalf of the minor, somebody will act as a custodian or the guardian. Then it will be deemed that he is going to realize it. Of course, once it is emancipated major, then either he wants to repudiate it, relinquish it, or he would accept it, whatever it may be his wish. So a minor is allowed to enforce the contract with some of the benefits to him and under rules that he required. A person who is not competent to enter into a contract by reason of the provision of the Section 11 of the Contract Act of 1872 can still be a beneficiary under the contract of insurance. Even though he doesn't have the capacity to contract, but still he can be a beneficiary under the insurance contract. Is it or not?
Yes, sir.
A minor's
Yes,
property
sir.
may be insured by person competent to act for him. So he would be entitled to recover the insurance money even though he is not party to the contract and he is not having the capacity to make the contract, but still he is the beneficiary of the contract. Hence, insurance money he can claim it even though he is a minor. The court rejected the defense of the insurance company that the person on bare obligation, the insurer has to be qualified for the job under the Life Insurance Act in 1956. The life insurance business in India, the general insurance was privileged of the carrying of the life insurance business in India. Either with the life insurance or with the general insurance, even a minor can be protected over there and he can get the benefit out of it, even though he is not the party to the contract. Is it?
Yes, sir.
With the contract between the father and the medical doctor would be there for the operation of the minor's son. Even the son is not a party to the contract, but son still he can bring an action against in the form of negligence, and the father can bring the action because of the breach of contract between the professional negligence of the doctor. Is it or not?
Yes, sir.
Yes, sir.
The general insurance was the exclusive monopoly of the general insurance company under the general insurance business. There is the Nationalization Act of 1972. For the Development Authority of 1999, the authority can grant a license for the insurance business. Now, the exclusive monopoly has been ended under the insurance regulatory and other also. Because at the time, there is the exclusive monopoly would be there for the insurance company. But once the IRDAI has come over there, it will be a check and balances to see to protect the interest of the insured. So what is the legal purpose? The purpose of the insurance of the Issuance of the insurance policy must fall within the legal framework. An insurance contract encouraging the illegal activity is invalid. No illegal activity will be there. A watchdog would be there. IRDA will take care of it. In addition to that, ombudsman also there who can take care of it. Section 23 of the Contract Act 1872 prescribes the requirement that the consideration for and object of the agreement must be lawful. If the lawful agreement will not be there, then the contract is void. In the same manner, there should be a lawful agreement must, as per the section 23. Everybody, do you want to contribute something? Because I heard your voice. Shall I proceed?
Yes, sir.
Very good. It has been held that there is nothing unlawful in a vehicle insurance policy providing that no compensation would be payable if the vehicle was being driven at the time of the accident by an unlicensed person by a learning license holder. Section 64, capital B of the Insurance Act 1938 prohibits the insurance from entering into a contract unless the premium is paid in the advance. Now the question comes over there in the most of the cases. Even though the person who is driving the license at the time of the accident, he doesn't have the valid license. But still, the insurance company should have to pay to the victim later on. He can reimburse from the person who drove the vehicle, driven the vehicle without a proper valid license. Okay, the court said that such conditions should be waived. Law does not help a person recover anything under his own crime. The fruit of the crime is irrevocable. No person is allowed to benefit from his own crime. Definitely, it is on this principle that a person is not permitted to participate in a succession which he has brought about through murder. Suppose if he is only one son to the propositors, and the propositors and this fellow who is going to inherit the sole property, absolutely, he is murdered the father. But when he murdered the father intentionally so that he could get the property, at the time, the court sees that and that boy and who is the sole owner or heir will be disinherited. Is it clear?
Yes, sir.
Very good. An insured person committed suicide is to enable his representative to get the insurance money, but they are not allowed to recover. It was an attempt to confer the benefit through his own crime. He brought about the undeserved punishment of the representative. The position was therefore changed by the Suicide Act of 1961. The principle was again applied to prevent the person who had taken out a policy in respect of liability for the bodily injury caused by the accident from recovering, but it is the result of the unlawful and violent attack, criticizing such a results. Now the question comes over there. Suppose a person is a nominee in the policy, and this fellow make the policy holder to die by poisoning him. Then he is entitled for the total amount liability, total compensation from the insurance company if it is proved that this fellow has administered the toxic substance in the food.
The medical report, as per the medical reports, it will be denied.
It is the medical representative says that the policy holder died not with the natural death, but he died with the poison. If that is true over there, then the question comes, who administered the poison? Because no one would be administered the poison unless until there would be a vested interest in him. Are you following me?
Yes, sir.
Yes, sir.
Yes, sir.
Of course, probability would be there. First and foremost, who will become the victim? Housemaid. I don't know why the people want to make the housemaid would be there, the victim first. Because she is a poor. No, what way she is going to get it? Because she is not a nominee. Are you following me?
Yes, sir.
Yes, sir.
Generally, the people doubt on the nominee. And moreover, they will also check what is the habitual, whether the nominee is a habitual offender or not, whether he is hanging in the criminal record or not. They will check it. But no one kills the father. Because when the father having the own death also, then entire property or entire things generally goes to the legal heirs. Of course, for the sake of the money now, brother will kill the brother and sister will kill the brother or brother will kill the sister because money plays many roles. Of course, free consent, it is one of the conditions would be there where when the insurance contract would be made. No compulsion. So whereas the 56-year-old man got himself insured and died within 2 years. I repeat, where a 56-year-old man got himself insured and died within 2 years of heart ailment. The Life Insurance Corporation refused to pay on the ground that he suffered from the diabetes and he did not disclose it. But the family doctor produced by the LIC as a witness could not give any information about the family. It was held that the fraud was not proved. The court said that the insurance of man of that age carried its own risk, and LIC had accepted with its eye wide open. Suppose once the medical doctor agreed that he doesn't have any disease, later on it is found that he is having some disease, but still LIC would be held liable to pay the compensation. See, recently a decision has come in the Supreme Court also. It is viral also. I think you might have seen it. Once acceptance is made with a medical ground, but later on, insurance company will not take the plea that he is having the so-and-so thing. When he is having the so-and-so disease, why the medical doctor will not make it clear in the first instance? Tell me. Sir, he colluded with the policy holder. Is it? If such a thing would be there, he would have to shown to the other doctors for the second opinion or the third opinion.
Opinion.
Am I right?
Yes, sir.
Yes, sir.
Okay. So where a motor vehicle insurance policy was issued after the due verification about the ownership of the vehicle, the company was not allowed for an accident take place. The plea that the policy was obtained by misrepresentation that the claimant was not the owner of the vehicle. Suppose once the insurance company has given the policy to a person and who is not the owner of the vehicle, how a person would do the insurance without the RC book where his name is not appeared? Sir, he can do the miracles even by the graphics, by using the digital mode. He can change the name, he can put it as if that he is the owner of the vehicle. If it is so, what about the Aadhaar card? What about the biometrics? So nowadays the biometrics will play an important role. So where the false answer to the state of the health were given in the proposed to life insurance, the policy is held to be voidable. It was not a material that the medical officer of the corporation had certified that the life assured is as good. Where a person got his motor vehicle insured, the evening of the day on the morning of which his vehicle met with an accident, the policy was held to be enforced. The duty of the insurer to check the vehicle notwithstanding. So now it is the insurance company, the burden would be there to see whether the person who is insuring the vehicle is the owner of the vehicle or not. Are you following me?
Yes, sir.
See, when you are going to marry a girl or when you are going to marry a boy, and you will make the inquiry from various other sources, sir, the boy or girl doesn't have any devices, no evils, no nothing, a very pious man, and he never drinks, never smokes, and never go to the movie. Are you following me? Never go to the even nightclubs and so on and so forth. If they so, you have to ascertain yourself from the various sources what is said is the truth or not. Is it or not?
Yes, sir.
Yes, sir.
In case they have visited the doctor to ascertain whether it is a positive or negative for the AIDS or Omicron or COVID-19, yes, they can go to approach the doctor and say that, sir, my daughter or my son is going to marry so and so person. I would like to know whether that man or she is suffering from the Omicron or the HIV AIDS or not. At that instance, the doctor privacy would be there to protect somebody's life. He will reveal it, but he never speak in front of the public or he never give the information in the newspaper. Is it or not?
Yes, sir.
Good. So insurable interest. See, whenever you have a certain thing, subject matter that we want to insure it, so that is the insurable interest. Is it or not?
Yes, sir.
The subject matter might be insured. The policyholder should have a monetary relationship with the subject matter. The relationship between the policyholder and the subject matter should be recognized by law. In other words, there should be not any illegal relationship between the policyholder and the subject matter to be insured. Of course, there is a legality would be there, then only he will make it out. But somebody's property, you cannot insure it unless until he is the owner of the property. The financial relationship between the policyholder and the subject matter should be such that the policyholder is economically benefited by the survival or existence of the subject matter or will suffer economic loss at the death of the existence of the subject matter. Unless until you don't have any interest in the subject matter, you don't insure it. Am I right?
Yes, sir.
The subject matter is a life in the life insurance, property and goods and property insurance, or liability or adventure in general insurance. So suppose if you want to have you purchase a very, very good car, very costly car, Ferrari. say that Ferrari you are purchased over there. And at the time that you will see that you will be insured because it is a very costly car. So we are interested towards the see that you should be protected from all untoward incidents like accidents. Okay, insurable interest is certainly a primary interest. The loss caused to the fire happening in the issued risk must be capable of the financial valuation. No emotional or sentimental loss, either an expectation of the anxiety would be the ground for the insurable interest. The event insured should be on that if it happens, the parties suffer the financially, and if it does not happen, the party is benefited by the existence. Suppose the accident happen, he is going to get the indemnified amount. Suppose the accident doesn't happen, okay, he will lose the premium only, which is a meager amount. Is it or not?
Yes, sir.
Yes, sir.
Yes. But a mere hope or expectation, which may be frustrated by the happening to some extent, is not an insurable interest. So always insurable interest means where do you have the good relations with the subject matter, and it will not be illegal way to get the opportunity to see that you should even insure the subject when you are not the owner of the property. So these are the certain things where you will come regarding the insurance contract and
Indemnified.
indemnified contract. Now tomorrow class we will see the insurance contract versus contingent contract. Before you come to the class, you please read what is the contingent contract and whether contingent contract is a contract in the insurance contract or not, whether the wagering contract is a contract in the insurance contract or not, and we will see in the tomorrow class. By that we would like to say bye to everyone. So now I will say that thank you very much. Also, I don't know whether I put the thank you very
Thank
much.
you, sir.
Thank you, sir.
Thank you, sir. Thank you very much, sir.
Okay.
Thank
Let
you,
us be. Thank you very much for your
sir.
patient listening. And now I would like to close my session. Then say goodbye. Stop sharing. Then end of the meeting. End of the meeting.